Morning, class.
Good morning,
Good
sir.
morning, sir.
Good morning, sir.
Morning. Yeah.
Good morning, sir.
Good
Good morning,
morning.
sir.
Good morning. You're welcome to today's class. Just before I came on board fully, I noticed there was one Jennifer who was trying to show her beautiful face to all of us. She should be ready to pay for that advert. Jennifer, I hope you can hear me. Okay, so on that note, we like to welcome you to this class. And I believe I hope you can hear me.
Yes, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Okay.
Yes, sir.
So I believe you have been following us and you do not have any issue whatsoever relating to the mode that we have engaged in teaching this course, especially in this course, the style, the speed, and other things deployed in the course of the lecture. So I want to believe that we are working towards making everybody, at least if not everybody, the majority to be happy, and at the same time we carry them along as much as possible. So with that, we glide into today's class, and I want somebody on this platform to give us a brief rundown of what we did in our last class to refresh our memory, and consequently, we can glide into today's lecture. I'd like to call someone from the box. At least if I call you and you did not answer, that means you didn't come for this class. You only put on your Zoom and then you walk your way. Can we have Sapara Ayomide Monsurat to give us the summary of what we did in our last class? Sapara Ayomide Monsurat. Is she, or I think that should be a she. Is she there? Or she's one of those locked down and went on for other businesses? Okay, I'll take her as that. Odubote, Miss Limat. I think I know that woman. Are you there? Odubote, can you remind us what we did in our last class? Okay. That one too is not there. Can we have Obafunke Johnson? Absent also. I'm noting those names. All right. Let me take those who have indicated. Again, I will try. Yes, Taiwo Anuluapo, yes. Can we have you?
Good morning, sir.
Good morning, sir.
Good morning, sir.
Now, Dubote,
Yes, sir.
go ahead.
All right.
Taiwo,
In the
just
last,
hold on. Hold on, let me hear Dubote.
In the last class, we did customary law, which is the law of indigence.
Law of indigence.
Yes, sir.
Wow. So that was all you had in the course of that class? You don't know how to give a summary of a lecture? All right, let me give the willing people room. Taiwo,
Good morning, sir.
good morning. Yeah, go ahead.
So in the last class, you taught
That Taiwo.
customary law, and you said that. Yes, sir, this is Taiwo.
All
So
right,
you
go
said
ahead.
that customary law. You said that customary law is the law of various indigenous people of Nigeria. That is, customary law is a rule, that is a norm that belongs to a particular people. And you also said that customary law is accepted, that one of the features of it is that it is accepted by the people and it is binding on them. You also said that it can be defined as the various customs that is prevailing and is in existence throughout Nigeria. And you said it is a very, very important source of law that governs like several parts of our lives in Nigeria. And before the advent of British, that we had like indigenous African societies that have their own laws, govern their affairs, like in marriage, sharing of properties and all of that. But you said it was not like sophisticated, although it was sufficient and it's like met the needs of the people. And you defined customary law. You gave us the definition of customary law according to Obaseki GSC in the case of Oyewumi and Oguniso. And you said that Obaseki defined customary law as the organic or the living law of indigenous people of Nigeria that is like regulating our life and transactions. So and you also said that customary law is like it mirrors the culture of the people. And you said you also gave us the definition of customary law in Kharie Zaidan and Mohosen, and you said that customary law is not a law that is enacted by any competent legislature. Then after that, you moved to characteristics and you gave us like about 7 characteristics. You said it is largely unwritten. It must be in existence at the material time that the customary law is being relied on. You said it must like enjoy a general application among the people, which you already explained that before, that it is usually like accepted and binding among the parties that is relying on it. You also said that it differs from tribe to tribe and that it is like particular to a set of people. And you said that it is not like rigid or a frozen system of law, that is, it is elastic and it is flexible. And you said it is based on customs derived like from a particular people. So that's all. Thank you.
Thank you very much. Taiwo Anu Oluwapo Eniola. That was a beautiful one. And I think I should also give you a gift. But the gift is what I don't know yet. So you tell your coordinator. I think, what's his name now? Not Sugar should be on this platform. So let Not Sugar remind me before your exams.
Yes, sir.
All right. Okay, so thank you for that brilliant summary. And it shows that majority of you are following us. And I will expect that you continue in that spirit because nobody, I repeat, must fail this course. Nobody must fail this course. That is an order which everybody must work towards to obey. And like I always say that what you're going to have, it's in your hands. And again, we have put all the grades in a basket. We have A there, we have B, we have C, we have D, we have E, we have F. So you are going to pick the one that you want from there. And the picking is not by dipping of hands. I'm picking. It's by the work you deploy in studying the course. All right. So we'll start off from there by saying that it is not every custom of a particular people in Nigeria that is regarded as customary law. That is the platform upon which we are starting this lecture this morning. That it is not every custom of a particular ethnic group in Nigeria that is regarded as customary law. Why? Does this not sound contradictory to the position that we've had? Does it not sound different from the explanations that we have given so far? Well, to clear your doubt, it doesn't sound contradictory, but in a way, creating an attempt to expand knowledge on the subject matter. But let that be the premise upon which we go into the argument and the submissions that we have for this class today. Consequently, for any customary law, custom to be recognized as a customary law, the custom must, as a matter of must, pass through what is known as the validity test. This will enable the custom to be judicially noticed as a customary law, which may further enjoy general usage, applicability, and for other purposes. So the focus then will be, what are these validity tests that a custom must pass through before it can be regarded as a customary law? So we are going to examine the various validity tests in order for us to appreciate all that we are talking about on this particular source of Nigerian law, which is the customary law. So when we talk about the validity test, we talk about the established rules and tests or yardsticks that have been put in place to determine customs that will be regarded as laws. So to begin with, I also need to put on record that Nigerian customary law has its fair share of laws that we outrightly consider abhorrent. That is, we have customs that we consider to be something strange, not common. Some are even deemed to be barbaric. Why some will be seen as this particular custom do not accord with nature. So when we have that in mind, then it gives us a reason to indeed consider whether or not every of our customs should be considered as customary law. Of course, like I said ab initio, there are customs that are considered, permit me to use the word disgusting. They are repugnant and then should not be applied against humans. Those customs do exist. If I open the floor for you to comment, give me examples, or I think I should hear from you. Customs in your own ethnic group that are considered disgusting. Can you share with us? This will lay a very good foundation for us. Divine or Generable. Yes, I will take as
There
many
is
of
the
these.
female genital mutilation.
Okay, as a custom which is considered as disgusting, right? Okay.
Yes, sir.
Ogabo, can we have you?
Okay, so in my place, not in my place, but in there's an ethnic group in Cross
Are you
River.
trying to deny your place now?
No, not my place, sir.
Okay.
It's not my place, but there's an ethnic group in Cross River where they eat people, even
Okay.
in today's day. So I think that's a barbaric.
They hit people.
Yes, sir.
Wow. Wow. That's
And I've
noted.
come
Sir,
to
that is not
You said, Ogabo, are you still talking?
Yeah, I actually thought it was just a myth, but I asked my mom and she was like, there's a sort of truth to it.
Okay. Wow. That's serious. Williams, let's hear you. Joy, Yeko, Badamosi, any of you can speak.
Okay. Good morning, sir.
Morning.
So there is this custom of a widow having to drink the water of her dead husbands, the water they used to beat for her dead husband. So she's going to drink
Okay.
it to prove her innocence, something like that.
Is that from your own ethnic group?
Yes, sir.
Which ethnic group is that?
Isoko.
Okay. I schooled in Isoko land. I never heard of that. I schooled in Ole.
Yeah.
Okay. That's
Okay.
noted.
Okay, good morning, sir. Okay, so this is not from my own personal ethnic group, but the practice of child marriage, which is very predominant in the north. I think that's a barbaric custom.
Okay. All right. Badamosi, Ogechi.
good morning, sir.
Yeah,
Morning,
good
sir.
morning.
Morning, sir. Sir, I won't go so far as to say barbaric, but there is a custom in my land in which when a woman loses her husband, she cannot leave the house for like 40, 50 days. I do not think that is necessary at all.
Okay. All right, that's noted. Emedo,
Good morning, sir.
morning.
Good morning, sir.
Yeah, go ahead. Good morning.
There's a custom in my land, that is in Igbo land, Imo State to be precise, that when you come to marry and they call it
Okay,
Onwafo, that's a child of the
Sir, I just
soil.
want to.
When you come
Sir,
to
can you
marry a child of the soil and
Sorry,
you're
can you
an
hold on?
outcast,
Emedo is speaking. Yes, go ahead. You said it's
and
called
you're
what?
like if you're a son of the soil, then Onwafo, you're a child of that land.
Wafo.
And yes, and person coming to marry you is an outcast called Osun. So there's
Okay.
a tradition done that the upper part, the lower part of the palm wine will be poured on the ground. And it will be said that if this person is an outcast or a bastard, that his leg will never come to this compound again. So most of the times there are stories, and it has been proven to be true, that most of the time when they leave that compound, they never come back again. So that is the tradition.
Way or they die.
I don't know of that, but it heard they never come back again.
Wow. Wow. Okay.
Good morning,
That's
sir.
morning.
So there's also the tradition of the king horsemen, also known as the Abobaku, where a man is allowed to enjoy the luxuries of being a king, and it's also compulsory that the person dies when the king dies.
Okay. Yeah, this is
Good morning,
where
sir.
John before dying. Okay. Yes, let's hear more.
Good morning, sir.
Good morning.
Yes, sir. So also there's this costume about when the kings die, the next king, the person that will become the king after him, we have to eat his heart, like his organ. That's it in the heart. In Yoruba they call it okonba, like to have the heart of a king, you have to eat the heart of the former king that passed on before you can become a king.
Wow.
Yes. Also
Good morning,
marrying
sir.
your wife and stuff like that.
Marry what?
Your late
The late Oba's wives.
the late brother, like your late brother. There's a tradition in Yoruba, like if your elder brother die, you have to marry his wife because
Okay.
your brother is dead body. So you have to take responsibility for his family, something like that. It's kind of
All right.
disgusting, actually.
Okay. Yes, let's take more. One, two
Good
more.
morning, sir. Good morning,
Yeah.
sir. There's a custom in Igbo land where female children are not considered as children. So if a woman marries her husband and she does not have a male child, it's not considered that she's actually married. So if they should bring a younger lady, even if she's not married to that particular man, they're supposed to do things according to like how they married the woman. Like this is the first wife, second wife, even though it's not from the same man, but within the same family. If the younger wife should have a son, then the elder wife, they will have to, like, if they are sharing things, that one would have to wait for the younger one to take and pick everything before she can pick. And sometimes nothing reaches her. And then the children, to the female child, if the father should die, the brothers will seize everything and leaving the wife and her daughters with nothing.
Wow.
Okay, good morning, sir.
Good morning.
So, sir, there's this custom that they have. I don't know if it's the Yorubas, but it says that when you accidentally kill a dog, that you
Yeah.
must place money in his mouth, or less like doom will fall before that person, like person will have the accident or something like that.
Wow.
Good
Good
morning,
morning,
sir.
sir.
So is it dollar that you have to put or naira, or what kind of money?
No, it's naira or coins.
Okay. All right.
Good morning,
Next.
sir.
Yeah, good
Good
morning.
morning, sir. Okay, so there is this tradition in my place that I find very discriminatory.
Okay.
When a man dies, the wife is she's supposed to cry, she's supposed to mourn. In fact, it used to be when I was much younger, I realized they used to mourn for like a year. They're not able to go to the markets, to church, to farm. They just stay within the community, and the family members provide all of her needs. But I think in recent times, because of the hardship and everyone is just looking out for themselves, it's like they've reduced it. So the wife is supposed to mourn for a long time. She's supposed to mourn for her husband. But when a man dies, when a woman dies, sorry, the man in fact is not allowed to see the corpse of the wife. It is forbidden for the husband to see the wife's corpse, and even before she's buried, probably the body is laid in the morgue. The husband will be given a woman to stay beside him. Like the wife has not been buried, but they give him another woman just to stay beside him and keep him company. And when I asked why, I was told that the spirit of a woman, the late wife, is usually very strong. So, and she and is very jealous that if the husband is left alone, without the woman by his side, the wife can come and take him. The spirit of the late wife can come and take him. So I find that very discriminatory when a woman is allowed to mourn her husband, but the husband is not even allowed to see the cause of the wife, let alone cry.
All right, thank you.
Good morning, sir. Good morning, sir.
Good morning. Let's keep
Sir,
let's keep the other examples for future use. Okay, I appreciate all of you and the contribution that you have made. As a matter of fact, it has brought so much light to the discussion that we are having. And I'm also glad that the examples that were given relates to practically every major ethnic group in Nigeria, which shows that in practically all our indigenous ethnic groups, there are practices, customs that people do not agree with. Of course, some deals with the fact that it's discriminatory, some is humiliating, some we can't really place, where they belong. So it is because of all of these circumstances that the validity test is introduced. Apart from what you have mentioned, as a matter of fact, why people were making those contributions, I still had close to about 11 hands raised up. I'm sure they were still going to tell us many of such instances or such customs that fall into this class of being abhorrent. So, if such custom must not prevail, the only way to ensure that that is achieved is when they are not allowed to be fully, propagated or made to become a regular occurrence. Because as it stands today, even though those customs are still being applied, some of them are applied discreetly. Why? Because the people believe that, oh, this thing indeed is not supposed to be so, especially in this time and age where the issue of human rights is very key. So that is to show the extent of acceptability. Even some are not done for people to know. They are done maybe within the house and done in such a way that, people don't get to know. But the truth remains that these customs remain in place. So if they have to be applied openly, they must satisfy certain requirements that the validity test must, as introduced in order for them to, remain valid or remain as customary law in Nigeria. So the validity tests have remained in Nigeria legislation since the colonial times. And in the present dispensation also, you can find them in the High Court laws of the various states and even of the Federal Capital Territory. That all these validity tests are going to discuss, there are requirements in those High Court rules, meaning that before any of such laws can be applied, they must satisfy, the requirements. Up until very recently, like someone rightly said, a female child in some certain part of this country cannot inherit the property of their late father. And then what comes to mind is that it is not only male children that are children, that such customs are highly discriminatory, because as a matter of fact, we have women or female children who are even doing more wonderfully well than even male children in terms of taking care of their parents, in terms of being responsible, and so on and so forth. So there was a whole lot of arguments on this fact. And thank God today, I think there are, judicial that has received a lot of judicial blessing in that it can no longer hold sway as it used to be. So if we take it down a little further, we look at section 44 of the High Court of Oyo State, High Court Law of Oyo State, 1978. That section 44 provides, and I quote, customary law will be applicable in a court if it is not, 1, repugnant to natural justice. Then the question will be, what is natural justice? If it is not repugnant to natural justice, equity and good conscience. The law continues that it is not customary, if it is not contrary to public policy and or incompatible directly or by implication with any law being enforced at a particular time. What that means is that the High Court Law of Oyo State of 1978 already made it clear that before any custom can become applicable, such law must not be repugnant to natural justice. Natural justice will say that all humans are equal. So why should a male child have more privileges than the female child, especially when they are, products of the same parents, not even people that you consider as outcasts or illegitimate children, even though there's nothing like that under the law. Every human being born of particular parents, they are legitimate children, because the Constitution of the Federal Republic of Nigeria does not approve any form of discrimination. So that whether the conception or the act that led to the birth of the child took place under the bridge or in the bush or in the gutter, it is immaterial. What is material is that this is born of a parent. Consequently, he should be given the right that they so desire. If you also see section 18, sub 3 of the Evidence Act of 2011, you also see a similar provision there, indicating that this requirement that the custom must not be repugnant to natural justice, equity and good conscience, and it must not be contrary to public policy. It's a must that those requirements must be met. So consequently, by virtue of this provision of the High Court of Oyo State law, we have identified that there are 3 basic tests which are referred to as the validity test. Number 1 is the repugnancy test. That is, not repugnant to natural justice, equity, and good conscience. Number 2 is the compatibility test. That is, not incompatible with any written law or legislation enforced, while the third one is the public policy test, that is not contrary to public policy. So we're going to dwell on these three tests, in this class, and if we are not able to finish it, we will take it on the next adjourned date. Oshinuga, you're raising your hand, you have a question?
Sir, no, it
All
was
right,
before.
question, good morning. Anuluapo, do you have a question?
Yes, good morning, sir.
Good
Sir,
morning.
please, equity and good conscience, they fall under what? Because I think I've written about four. No.
Repugnancy test.
Okay, thank you, sir.
When we're talking about the three tests, again, I repeat, we're talking about the repugnancy test, talking about the compatibility test, and the public policy test. So, well, as we delve into all of this, we need to know what we mean by these three tests, and then it will give you the understanding that we require. Now let's take the first one. Or let me welcome contribution from the class. That what do you understand by the repugnancy test? I know many of you have been studying, and then let's see how far you've gone. Anyone? Taiwo, go ahead. Williams.
Okay, good morning, sir.
Good morning.
There. Okay, so the repugnancy test simply means that the custom itself must not be the custom that is being contested to be applicable as a customary law must not be repugnancy means unacceptable or means unacceptable. So on the basis of the natural justice, that custom that has been contested to be a customary law must not negate the principle of natural justice. And the principle of natural justice itself is embodied in the twin maxims. Audrey is embodied in twin maxims, among others, Audrey Atrium Patem and Nemo Jesus Ikaswaswa. So this natural justice simply means that everyone is equal, and like you explained, right, the custom that there's discrimination between a male and a female child cannot have general applicability in the court of law, because that negates the principle of natural justice, which is a very fundamental principle in the legal system of any nation. So basically, the custom that is being contested must not differ or must not negate this principle. So, and it's also actually a very important test for the applicability of a custom, because we cannot have in general application a custom that separates, or that on the basis of unfair or arbitrary rationales separates people, or widens the gap as to maybe provision of social amenities or whatever to people. For example, inheritance now, and somebody mentioned, I think it was, I'm not sure, but somebody mentioned that as relating to inheritance and whatnot, female children are not seen as eligible to inherit their parents' wealth or whatever their parents left behind for them. So on the basis of this test, this cannot apply as a general customary law, because it already fails on the first test, which is the basis of natural justice. So thank you, sir.
All right, thank you very much, Williams. That was a good one. So building on that, I agree with his submission expressly, and I would like to add that when we're talking about the repugnancy test, the test only requires that a custom should not be repugnant. That is, it must not be repulsive. It must not be disgusting to natural justice. Natural justice, of course, is a term that we are going to look at, even though it's very difficult to explain or very tricky. Let me use the word tricky to explain. But we will see it as we move on in the course of this lecture. So, if a custom is found to be repugnant to the fundamental rule of equity, the court is enjoined to ignore such. Example is seen in having a male and a female children, and the female not having the capacity in law to inherit the property of the father. That's in the way negate the rule of rule of equity that talks about, fairness. And then the court, by virtue of available rules, is enjoined not to in any way approve of such customs. Many of those examples that were given earlier on in this class by the legal minds here are very hard when we are looking for example in this particular heading. Now, what do we mean by natural justice? It is important that we are able to dwell on this so that, we have a better understanding of what we're talking about. Now, like I said earlier, that it can quite be tricky to try to get an exact meaning of natural justice, equity, and good conscience. So, because this concept varies from society to society, so therefore, one needs to take caution in trying to determine what is natural justice. While some society view respect for others as immutable, some pay a passing reference to it. For example, in Yoruba land, if you have an older brother who is older than you by a day, there's this level of practice that expect you to add brother to his name. That is the rule, the rule of practice or custom. The brother Shegun, and then just like we will say it in Yoruba, brother mi Shegun or brother Shegun. Yet, in some other ethnic groups, it doesn't mean anything. It is not important. So therefore, if in Yoruba land, a younger person should disrespect an elder, it is a serious issue. And that means that individual has done contrary to what is expected of him or her as an individual. So it can be punished. But the question is, the question therefore will be, why should he be punished for simply referring to his older brother by name? To some people, that is irrelevant. Why to others, it is important. It is key to their existence. So, Are we going to say that those who take the issue of respect seriously, they are not modern people? The answer is a no, because that is a practice that is acceptable within that society, and therefore, as far as it does not in any way bring harm to any person, such should be considered as natural justice for those people. Now, regardless of this confusion that we may be in as to determining what natural justice is, we can get a bearing on the meaning of this term by looking at the various decisions that have been arrived at by our courts. And then that means, therefore, we will engage the realist school of thought in defining what natural justice, equity, and good conscience is all about. Now, I'll refer you to a case of Danmolle versus Dawodu, reported in 1958, 3 FSC 46. Also reported in 1962, 1 All Nigerian Law Report 702. What is an issue here? It is an issue relating to natural justice, equity, and good conscience. So, Taiwo, you have a question?
Sorry, sir. Please, can you spell the Dawodu for us?
Danmolle is DANMOLE. Danmolle versus Dawodu. Dawodu is spelled DAWODU. A terrorist has invaded this class. Thank God we'll be taking the person off. Okay. So, what is our focus on this case? Among the Yorubas, the sharing of maybe the deceased or if parents in property, according to the number of wives, or don't let me even go that way. We're talking about sharing of a deceased property by his family. Now, the sharing is normally done according to the number of wives. That is per stripes or idigi. Okay? So it can be done in that form that if a man had 4 wives while he was alive, when the property is to be shared, it will be shared by the wives. Irrespective of the number of children each wife has, it doesn't matter. But it should be shared past what we call past tribe or by the idigi system. Another way it can be shared is that it can be shared by the number of children. I'm sure there are people in this class who already have inheritance, either per capita or maybe ori ojori as it is known in the Yoruba customary system. So the pastra talk about idigi, that is by the number of wives, while the per capita talks about the ori ojori, meaning by the number of children. So irrespective of the number of wives, under the per capita or the ori ojori system, the property is shared in accordance with the number of children of the deceased individual. So, in this case of Damole versus Daudu, once Shuberu died, he died without leaving a will. And then he left behind 9 children by 4 wives. Okay? And according to Yoruba customary law, the property is to be shared in some certain ways, like I mentioned earlier. Apart from these 9 children and 4 wives, the man had a number of grandchildren. And then this matter got to court. At the trial, the plaintiffs failed to prove the existence of a will, but they adduced evidence of a Yoruba native law and custom of Lagos, known as Idigi, whereby the estate of an in-estate or someone who died without a will is distributable according to the number of the mothers of the in-estates. That was the argument of the plaintiff. On the other hand, the defendant claimed that the proper and appropriate native law and custom of Lagos in the circumstances was known as Ori Ojori distribution. That is, according to the number of children born by the individual, and not by the number of the wife that the man had. That was the argument. The plaintiff were of the view that it should be done in accordance with the native law of Idigi, whereby the estate is shared by the number of the wives left behind by the late man. Whereas the defendant were of the view that it should be done by the Ori Ojori, that is the per capita, or by number of children. That was the argument. The decision was reluctantly, the court, the Federal Supreme Court held on appeal that the distribution should not be among all the 9 children, that is the per capita, but into 4 shares per stripe according to the number of wives. Now, when you look at the ratio dissidenda of that judgment, you will observe that it is possible that one of the wives had 5 out of 9, and then the other one had maybe 1, and 1 had 3. So if it is to be shared, you discover that the one that had 5 children will have 5 different parts, which was considered not to be fair enough. But that was what was the decision that was reached. But is it not better that it is shared by number of wives? While others may hold that view, others may hold that no, let it be that each child is entitled to inherit from whatever the father left behind. This decision was followed, this decision in this case of Damole and Daudu was also followed in Salako and others versus Salako, which was reported in 1965, LLR 136. Now, under this custom, under this case of Dawodu and Damole, like I said before, the custom that was in question bordered on the Yoruba law of inheritance, and which says that when a man dies intestate with multiple wives, his property was divided according to the number of the wives he left behind. As a result, all the children of one wife inherited the property allotted to their mother's branch. And then, if they have about 5 children in that tree, the 5 children will share what it is that has been sent to their mother. So what the trial court did was that the custom was repugnant to natural justice because it negated the common law doctrine of equality of inheritance among the children. Meaning that it ought not to be so that all the children have direct right to inherit. So, on that ground, the matter was appealed, and the appeal was allowed to stay in the Court of Appeal. And the court stated that it will be erroneous to import doctrines of natural justice that apply in monogamous society to a polygamous one like Nigeria. Meaning that the only time where you can apply the Ori Ojori is when the children are of a single mother who happens to be a single wife to the late man. That in a polygamous setting like Nigeria, it may not be a just decision to go by the pastoral. These are the arguments that was on in court, front and back. But this argument may continue depending on the community where the law or where the custom is to be applied. There was another case where the court refused to apply this rule that it must be done by pastoral. That was the case of Guri versus Adeja Native Authority. Guri is spelled G-U-R-I versus Adeja, H-A-D-E-J-I-A, Adeja Native Authority. The courts did not apply a custom because it was not compatible with natural justice. In this case, what was in question was the fact that if a thief, a suspected thief, is caught on the highway, the rule of custom does not allow him to defend himself. When you look at it critically, it negates the doctrine of natural justice, because you cannot hear one party and leave the other. The court did not apply this custom because it was contrary to the principle of fair hearing. In Yoruba land, they will say it is an Agba Oshika, or a wicked elder, that will hear the story of one side and fail to hear the story of the other party.
Agbejo ẹnìkan dá.
Washere, who is that? Say it clearly so that Others can hear.
Agbọ́ ẹnìkan dàgbà òṣìkà ni.
Agbẹ́jọ́ ẹnìkan dá àgbà òṣìkà
Àgbà
ni.
òṣìkà ni.
All
Bẹ́ẹ̀ni.
right. So that kind of custom is repugnant to natural justice. Sometimes in Yoruba people will say that when you catch a thief on a palm tree, he will have something to say. But what he has to say, is it not proper for you to listen to him? Now, let me give you this example as it's coming to my head. There was a man in the Bible who wanted to see Jesus Christ at all costs. Let's assume that the nearest tree that the man had to climb was a palm kernel or palm tree. The man decided to climb it. This man can give many reasons why he climbed it. He can say that he climbed so that he can see Jesus, or he climbed so that he can take selfie on the palm tree. It can also be that his intention practically may be to pluck some palm kernel fruits or to cut the leaves which can be used to make brooms. But is it not better to hear him? Especially in this era of skit making, where you see people in broad daylight playing pranks on people. So if you see somebody doing something like that, then the next thing you want to shoot the person down. It will be too hasty a thing to do. The same thing applies when we bring it down to the subject we're looking at. The native custom in that place is that once a thief is caught on the highway, nothing to say. He cannot defend himself. What if he was not a thief? What if what he was carrying, he recovered it from a thief, and then the owner suddenly saw him? That rule of custom violates the rule of natural justice. Consequently, the court did not allow it to stand. The court did not approve of it. Now, that is for validity test number 1. I don't know if there's anybody on the floor who want to give us an example, maybe from a particular case that he or she must have read. Anyone? Just to buttress the point that we are making. Yes, Franklin.
Okay, I once read one case, Mariama and Sadiku Ejo. So in that case, I've forgotten the land it was based on. So in that case, it stated that any man, if a man and woman get divorced, if the woman give birth to a child within 10 months, the child will belong to the father, to the former husband. Now, in this case, the man was not the biological father, but because of the custom, the woman insisted that the man was the father, that the son, that the child she gave birth to is a son of the former husband. So when they took it to court, the court said that it is repugnant to natural justice because it is not the man's son, and that she's not entitled to any kind of like maintenance or anything.
Well,
I'm done, sir.
Yes, thank you for that. Now let me add to what you said. I expected you to give the ratio for that decision, the ratio decidendi. That's one of the ways you can learn this key point that we're talking about. Now, what do you think is the rationale behind that position? That the rule is repugnant. If a
I
woman,
believe.
go ahead, go ahead. You want to say something?
Go on, sir. Go on, sir.
Okay. If a woman lives in marriage, month 1, month 2 up to 10, that woman could have engaged in sexual intercourse a month after she left the marriage. And then definitely by the circle of life, she will be expected to give birth on the 10th month. As a matter of fact, even if it is a day after 1 month that the woman left the marriage, if it is possible, she can be pregnant for 30 people at the same time. Or let's say 30 women can become pregnant in 1 day. So that 1 month is enough for a lot of things to happen, or to justify or to maintain the position that it was not the former husband. So if the law has to stand, it's like imputing into the man that without any option to verify that once it is 10 months after, then the man is the father of the baby. And unfortunately, those days, there was nothing serious like DNA test. But such is an example. Having a father, a man to father a son or daughter that he did not, was not responsible for. So therefore, one can, classify such example under this particular subtopic that we are looking at, which is a test number 1, that the custom must not be repugnant to natural justice, equity, and good conscience. So let's move on to test number 2, which is the compatibility test. What this means, therefore, is that this custom must not be incompatible with any written law or a law that is in force. Okay? So, despite the fact that there are rules of court that encourage the court of law to apply rules of customary law, such law must not negate an existing law. For example, let's assume that the rule that a female child cannot inherit the property of her father is being found or discovered at this time that we are in. That rule will not be applicable because the Constitution of the Federal Republic of Nigeria does not approve discrimination against anybody. So let's say this rule was just discovered. That rule is not compatible. It has failed the compatibility test because it's already in contrast with the particular law that is in force. And all of these laws that we're talking about even include the English laws. And then it must at all times be the one that we align, not as a matter of fact, be in competition or inconsistent with the law that is in force. If, for example, that inconsistency had to do with the Constitution, it is the position of the law that such law will be void to the extent of its inconsistency. Okay, I wanted to say that the Bible says, but it's the Constitution, that such law will be, to the extent of its inconsistency, become null and void. It cannot work. So for any custom to be applicable, to become a customary law, it must meet that requirement, because any existing law must have gone through the required process of lawmaking. And it is only when it's deemed to be a proper law that it becomes law that is allowed to stand in the society. That is the compatibility test. Do we have any question before I move on, so that we can clear the doubts before we look at the other tests? Any question or addition or subtraction? Okay. In the absence of any question, it is believed that that is well understood. Let's look at the last test before we call it a day. It's a public policy test.
How that come out today? Yeah, eti kini. Eti kini bono kini jare. Okay, ṣé you expect us to take back to kini boy? Ṣé you go to expect me? All our time about kini boy, we dey tún sọ pé kini.
And that person now is who are these people? I'll start penalizing people for this contempt of this classroom. Okay, let's look at the public policy test as a third test. According to Eze Malemi, that is one of the author of the recommended test, he said public policy on its own is quite difficult to define, but it can mean public welfare, public good, and public interest. So what it means is that any law, any custom that is found wanting in any of the ways as to assault or rape the public policy or public welfare will not be deemed to be a customary law. Because according to him, he said public policy means public welfare, public good, public interest. It so provides that a custom found wanting in any way as to assault or rape the public policy or public welfare, which by virtue of Section 14, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, which provides that the security and welfare of the people shall be the primary purpose of government. So therefore, any custom that violates this should be seen as one that tries to assault the general good of the society. So, public policy talks about public morality, public security, and public welfare. Another explanation that has been given on public policy is given by J. Jordan. J. Jordan describes same as ideas, that is, public policy are ideas which prevail in our society at a particular time as to the conditions which are necessary to ensure his welfare. That's what J. Jordan said. He said, and I quote, J. Jordan describes same, that is public policy, as ideas which prevail in our community as at the material time, as to the conditions which are necessary to ensure his welfare. So therefore, what it means is that a custom will not apply on the ground of public policy if it undermines the already established moral laws or laws in a society. And then, if it is that the case or the custom will not be applied. Let's look at a case of Cole versus Akinyele. Akinleye, sorry, Cole. C-O-L-E versus Akinleye. The custom that was in question here has to do with legitimacy of children born out of wedlock. Under Yoruba custom, if a father acknowledges a child born out of wedlock as his child, he will become a legitimate child. This means that he will have an equal right to inheritance along with those born legitimately in the marriage. Now, let me now discuss the fact of the case of Cole Akinyele with you. In this case, the deceased was married under the act and had an affair with another woman during the subsistence of the statutory marriage. While the other child was conceived during the marriage, but born shortly after the death of the wife of the statutory marriage, the issue before the court was whether the two children could be regarded as legitimate children of the deceased as a result of acknowledgement of their paternity by the deceased. Court went further that for the child born during the subsistence of the statutory marriage, the court held that it was customary to public policy to allow the father legitimize that child by another method other than the procedure by the legitimacy ordinance. In other words, the child cannot be legitimized by subsequent customary marriage, but by marriage under statutes. So that it was not sufficient for the father to just acknowledge it like that. The court acknowledged or noted in this case that those two children, or if that is allowed to stand, that kind of acknowledgement is allowed to stand, it will give room for people to engage in various acts of infidelity while in marriage. So, in the case, the father acknowledged the illegitimate child while he had other legitimate children under marriage ordinance. The court held that equating the right of a child born out of wedlock with the right of children born under the marriage ordinance will be contrary to public policy, meaning that men will now have the effrontery, have the power to do anyhow, and then, and have their way. The issue mainly is not with the woman or with the children involved, but for the society, because it will soon become a normal thing. Like I noted, I said the rationale behind the decision was that the marriage ordinance was of colonial origin. As a result, any custom that would try to undermine a colonial law would be contrary to public policy. Therefore, if a customary law can pass this validity test, it is well on its way to becoming a primary source of Nigerian law. So therefore, by virtue of the Constitution of the Federal Republic of Nigeria, Section 42, Sub 2, as amended, no citizen of Nigeria shall be subjected to any disability or deprivation merely by reason of the circumstances of his birth. Yet, we can say that this position supports the father acknowledging the child even though he was born outside the marriage. But the issue there was that there was already a law by the colonial authority that it couldn't happen. But of course, the Constitution of the Federal Republic of Nigeria does not give room for any form of discrimination. So, like we have mentioned, customary law is another very important source of Nigerian law because it governs issues of concern of the life of the people. Like I mentioned, issues related to marriage, native law and custom, divorce, succession, inheritance, land tenure system, and even chieftaincy titles. So all of these, are the roles or are the subjects that customary law covers. So, but what we are saying is that for such to be seen as a law, the custom must pass those tests that have been laid down by the various laws of these states. So with that, we come to the end of customary law as a source of Nigerian law. I think we'll take it up from there. Next time, we look at Islamic law as a source of Nigerian law. So I want to thank you for listening and request that you send in your attendance via the group chats as saying is being enabled at the moment. So thank you once again for listening. If you have any question, you can keep it in next class. I think someone sent a message to me, but I forgot to take it at the beginning of this class. Dorothy, please remind me next class to take whatever outstanding questions we have before we delve into the lecture for the day. Thank you once again for listening and enjoy the rest of your day. Bye.
Thank you, sir.
Thank you, sir.